Welcome to INAN's Student. INAN Student is a platform for law students to come here and deliver a lecture on the topic of their choice. Today we have with us law student Ananya Rawat. She is going to speak on Domestic Violence Act 2005. She is from KES Shri Jayantilal H. Patel College of Law. So without wasting further time, I would request Ananya to commence with her lecture. Thank you.
Good morning everyone. Today I am honored to speak to you about a topic that not just concerns with the safety and dignity of women but the well-being of our society as a whole. Domestic violence and the legislation designed to address it in India, known as the Protection of Women Against the Domestic Violence Act 2005. Domestic violence is one of the most pervasive forms of abuse in India, affecting millions of women across various demographics. It transcends boundaries like age, religion, caste, and socio-economic status. Despite progress in various fields, many women in our country continue to suffer in silence, subjected to domestic violence in their own homes, the very place where they should feel safe. In order to address this grave issue, the Parliament has passed the Protection of Women Against the Domestic Violence Act, also known as the PWDVA Act 2005, a landmark piece of legislation that aims to protect women from violence in the domestic sphere. This act represents a significant step forward to addressing domestic violence as not just a private family matter but a crime, one that requires legal intervention and protection. Now let us talk about what does the act cover. Domestic violence not just deals with physical harm, it recognizes that abuse can take place in many forms. First, physical abuse, which includes slapping, kicking, pushing, beating, etc. Second, emotional abuse, insults, threats, ridicules, intimidation, which may often go unnoticed but can be deeply impactful. Sexual abuse, any conduct which is sexual in nature, which humiliates, abuses, violates the dignity and autonomy of the victim. Financial abuse, depriving a woman of financial resources and forcing her to live into financial dependency. This broad definition ensures that domestic violence not just deals with physical harm but tells us the various subtle and insidious ways in which a woman can be demeaned, controlled, and oppressed. Now let's talk about who can seek protection under this act. The law protects any woman who is or has been in a domestic relationship with the respondent, that is the person abusing her, or who alleges to have been faced to domestic violence can file a complaint. The domestic relationship can arise out of marriages, consanguinity, that is blood relation, adoption, and even women in live-in relationships. The act is not exclusive just to wives but also to other women living in the shared household such as mothers, daughters, sisters, etc. The act recognizes that abuse can occur in any household relationship, not just from fathers but also from any male family members. Procedure of filing the complaint. A complaint can be filed with the help of a protection officer to the police or the magistrate itself. The aggrieved women can also approach an NGO for assistance in filing the complaint. Once the complaint is filed, the magistrate can take necessary cognizance and issue necessary orders. Now let's get to rights of the aggrieved woman, or what remedies does the act offer. The domestic violence is not just about criminalizing violence, but it also provides various civil remedies which would help the woman to rebuild their lives and regain her dignity. The Act provides several legal remedies and safeguards to protect women from domestic violence. First, protection order, section 19. The court can issue protection order prohibiting the woman to respondent from committing any act of domestic violence, which also includes visiting the victim at workplace or schools, communicating with the victim, or conducting any act which may cause physical harm. Second, residence order, section 19. The act provides that women has a right to reside in the shared household irrespective of the fact that she owns any legal title or ownership in it. The act prevents the respondent from evicting the woman and barring him from entering the house. The law recognizes the vulnerability of women who are often forced to leave their houses after being subjected to domestic violence. Monetary relief. Section 20. Protection against economic abuse. The law also recognizes economic abuse, which is often overlooked in domestic violence cases. Denying a woman of financial resources and forcing her life into penury can amount to economic abuse. Custody order, section 21. The act also gives the court the power to issue custody orders for children to live with the aggrieved woman. The respondent can have visitation rights if and only it is deemed safe and necessary for the children and the women. Compensation orders. The court may also order the respondent to pay compensation to the woman for injuries, that is physical or mental, resulting from domestic violence. Interim and ex parte order, section 23. In urgent situation, the court may issue interim orders without giving notice to the respondent for the protection of the aggrieved woman. Time frame for the proceedings. The Act provides for speedy proceedings with the magistrate required to start hearings within 3 days of receiving the complaint and try to dispose the case within 60 days. Role of protection officers. The Act mandates the appointment of protection officers by the state government. These officers act as a link between the victim and the legal system. They help the aggrieved women in filing a domestic incident report, securing shelters, process assisting in obtaining legal aid, and guiding them through the legal process. These officers play a critical role in ensuring the safety and protection of victim by making sure that the court orders are being implemented and to provide the financial and medical relief that they need. Service provider and shelters. The Act recognizes the role of service providers and organizations which also include the NGOs that offer legal, medical, counseling services to the victim of domestic violence. Shelter homes are also provided to provide necessary temporary accommodation to women who need immediate protection from their abusive domestic environment. Duties of the government. The provision of this Act must be given wide publicity through public media so that the citizens of our country are well aware of such provisions. Both the central and the state government offer such officers such as the police officers and the members of the judicial services must be given periodic sensitization and awareness training regarding the provisions of the Act. Appointment of protection officers, registration of service providers, publicity, that is publicizing the government to provide the provisions of this Act to the citizens. Training. The government provides training to the officers and members of the judicial services and issues addressed by the Act. Coordination. The government establishes coordination between the services provided by various ministries and departments, preparation of protocols, notification of the shelter homes. These are the duties of the government under the Act. Now let us talk about the landmark cases and judicial interpretation. One of the cases is Hiral P. Harsora versus Kusum Narottam Das Harsora 2016. The Supreme case in this landmark judgment struck down a portion of the Act restricted the meaning of respondent to only the male members of the family. The court ruled that the women also come under the respondent in cases if they are abating or committing the violence. Another case is the D. Velusamy versus D. Parchimal 2010. The Supreme Court ruled that the live-in relationship that resemble marriages should be recognized under the Domestic Violence Act. This judgment extended protection to women in relationships that are not legally recognized as marriages. Legal outcomes. The legal outcomes of domestic violence cases encompass various results, which are convictions. Successful convictions occur when the court finally finds the accused guilty of domestic violence charges. The outcome reflects the judicial system's effectiveness in prosecuting and penalizing offenders. Acquittals. Acquittals happen when the court finds the accused not guilty. This can result from insufficient evidence or legal technicalities, which may indicate challenges in the prosecution process. Pending cases. There are cases that are still under legal review or awaiting trial. The duration and resolution of these cases can impact the perceived effectiveness of the judicial system and timely delivery of justice. Evaluating these legal outcomes help us assess how well the judicial process handles domestic violence cases and identifies areas where improvements may be needed to ensure justice for victims. Now let's get to the main reason why, one of the main reason why domestic violence occurs in first place, which is dowry systems. Domestic violence often happens in India as a result of dowry demands. Dowry payments are another manifestation of the patriarchal structure in India. There is a strong link between domestic violence and dowry, a cultural practice deeply rooted in the Indian communities, where money, goods and properties are exchanged during the act of marriage. Why is this law important? The significance of Domestic Violence Act cannot be overstated. It shifts narrative. No longer the domestic violence can be issued as a family issue or dealt to be in private. It is a legal violation of women's right, and the state is obliged to address it. The act gives women the legal framework to step outside the shadows of the abuse and demand justice, support and protection. In conclusion, while laws like Prevention of Women from Domestic Violence Act 2005 mark significant progress, these are only the beginning. The real challenges lies in changing societal attitudes and ensuring that victims receive the support and justice they deserve. We must continue to push for better enforcement of the law, invest in support services and ensure that every woman knows the right and the means to access them. Furthermore, we should foster a culture of zero domestic tolerance, not just through legal means but also through educational and public awarenesses. Schools, workplaces and communities are the areas where the gender equality should be taught and legal norms which support violences must be destroyed. The Protection of Women from the Domestic Violence Act is a comprehensive law aimed in addressing the issue of domestic violence to all forms. The Act goes beyond the conventional understanding of domestic violence as merely a physical abuse and includes broader range of abuses, providing important legal remedies to women. However, a successful implementation of law remains a challenge due to societal factors, lack of awareness and issue of judicial system. Thank you.
Ananya, thank you very much. It was a nice overview of the entire Domestic Violence Act which has come in 2005, and I think this act needs more of growth, because in spite of that even we are listening a lot of nonsense activities with it. So I think this speech or this particular thing was very nice, it was interesting. So thank you very much, and a small token from us to you.
Thank you.
Thank you.